Good afternoon. I was about to say good morning. Good afternoon, everyone. Thank you so much for coming. My name's Nora Menken. I'm the Executive Director of People's Memorial Association and the Co-op Funeral Home. And we're very happy to bring you our Ducks in a Row program. You can see up here we've got my face again. We are starting a new thing where we're trying to record these presentations because so many people can't make it out to these that we want to have it available for them. So it's a learning curve for us, so we'll see how this works out. But I apologize for the distraction if that's going on. Tiffany Gorton will be speaking on estate planning. She is a attorney with KHBB Law Firm. And oh, it's right here. Oh, but I did memorize it there. With that, I'll invite Tiffany Gorton.
Thank you. In the KHBB stands for the founding partners of my firm. So Kutcher, Hereford, Bertram, Burkhart, KHBB being much simpler to say than all of that. So happy tax day. I'm sure that you were all racing this morning to get your checks out in the mail, or at least your filing vouchers. I know that there was a stack of them at my office for the folks that I practice with, and it being tax day, my tax and estate planning nerd jokes should be much funnier. So you're in for a treat. It is Benjamin Franklin who said, "In this world, nothing can be said to be certain except for what? Death and taxes." So I told you it's going to be much funnier on 415. So at this time, many of you probably know that there's both a federal estate transfer tax and Washington State has an estate transfer tax, sometimes called the death tax. But those threshold amounts, our friends in Washington have raised our federal exemption amount to $11 million per person. Here in Washington, it's a little over $2 million, $2,193,000. So I hope to have an estate tax problem someday. I don't currently, but I'm working on it. And so this presentation is going to be more about some of the important pieces of estate planning, some more foundational tools, so not a tax presentation. So you are a little bit lucky in that today. But if you do have tax-related questions or estate planning questions, and if we don't get to the questions on kind of the general foundational pieces today, feel free to shoot me an email, give me a call. I'm happy to answer any questions. I have to run after my presentation because I have a client meeting. So I will take questions during the presentation, but if we run out of time, feel free to send me an email, like I said. So in terms of kind of what we're talking about today, the more foundational and important nuts and bolts of estate planning, it's really, estate planning is about a lot of things that we talk about assets and things like that, but the bottom line is estate planning really is about people. It's kind of my philosophy in terms of this type of planning is making end of life decisions as clear and easy on your family members as possible, and making your ultimate passing, your ultimate death on your loved ones as easy, and that transition as clean and easy as possible. I spend a lot of my practice time, I do both planning and then I also do dispute resolution. So I see a lot of trust and estate disputes, and I litigate, I go to mediation, and so I see kind of the things that come up that can be thorny, to say the least, for families. And the foundation of having a good plan in place can really avoid a lot of that. And so you'll hear some of my highlights as we go through the different documents and some of the different kind of underlying theory in planning. I've pulled those from litigation, from when I've seen things go awry. So in terms of the estate planning being about people, some of the things that we think about in terms of our families and our people, our tribes, as it were, are there minor children? Do you have minor children? Do you have minor grandchildren that you're providing for? Because that takes some special considerations. Perhaps you are in a second marriage or a third marriage, or any number of marriages down the road that you don't share children in common. But you have kids from prior marriages. Do you have pets? Yes, I am originally from Michigan, and so things are a little different there in terms of planning for pets. But here, you can set up a pet trust and so, certain things like that. So I do catch some flack from my family members back in the Midwest. But although our beloved furry friends are treated like family and we value them as family, you have to make sure that you mention them in your estate plan to ensure that they go to the right person. What about philanthropy? We're here with People's Memorial Association and Honoring Choices, some nonprofit organizations. Are there organizations that are near and dear to your heart that you care about? The theater, the library. Where do you spend your time, and what organizations have your heart? Because that's something that's important in terms of your planning. One of the key pieces that I like to tell people the reason to plan is to avoid litigation. Again, I see bad things happen sometimes, and they're oftentimes avoidable. So making a good plan to avoid those things. Again, making your passing easier on your loved ones. Some people say, you know what, I don't have an estate plan. I don't have any assets. Well, true, you don't necessarily have, or they say, I don't have an estate. True, you don't have an estate until you're gone. But even if you have a Buick and a base fiddle and you want to make sure that those items are directed to, somebody who cares about them within your family, the holiday ornaments, the cookie jar, that sat on grandma's counter for 75 years, those types of things, they're sentimental. So maybe they don't have a dollar value, but they're important to somebody in your life, and you want to make sure that they're directed accordingly. A biggie, as we'll talk about with some of the first documents we chat about, is ensuring that there's somebody there that can make healthcare decisions and financial decisions if you're still living but incapacitated for some reason or another. So again, it's about the underlying folks. It's about you personally and the people that you care about, more so than the assets themselves. But like I say, everybody has different needs. So a lot of times folks will say, well, my neighbor has XYZ plan, or my parents did this, but then they leave out, but my parents live in California. So things can be different from one person to the other, and certainly different from one state to another. And so I like to say that estate plans are like shoes. Everybody needs a different shape, a different size. Some people need a wide, some people wear a stiletto, some people wear a loafer. So it's really important that the plan is tailored to meet your needs and your specific intentions. So what are the tools that we use? First, in my opinion, I think that the durable power of attorney for healthcare and for finances, that's really the most important piece. And the reason is you're still alive when those things become effective. And so you want to make sure, and I know that Bonnie's going to talk a lot about the details for the healthcare decisions, ensuring that your wishes are carried out. So I'm not going to necessarily talk about that here, but I am going to talk a little bit about the actual document and making sure, basically, principally, that somebody's on deck for you that can say, hey, Tiffany fell and hit her head, and now she can't communicate with her healthcare providers, and I know that here were her wishes. So I've been appointed as her agent. I'm here to speak on her behalf. Same thing with the financial piece. You want to make sure that there's somebody there who can come up and say, okay, we're going to make sure Tiffany's mortgage is paid because she's currently incapacitated, either for the foreseeable future or, for some sort of temporary issue that I have. You just want to make sure that and getting your ducks in a row, that there's somebody there to ensure that the bills you're paying currently by yourself with your checkbook or online, that there's somebody there to kind of step into your shoes and do those things for you in the event that you become unable to do so. A biggie that we think of, and every person in this room is probably touched by it in one way or another, is Alzheimer's or dementia. We run into it. My grandmother has it. My husband's grandmother has it. So we see that very frequently, and we know the outcome. It's not reversible at this point. And so ensuring that if something like that were to strike, you have well in advance a plan in place and somebody who can come along and say, okay, Tiffany no longer has capacity, but she is still living, and I need to make sure that her bills are paid and that her wishes are carried out for healthcare purposes. And the person you appoint doesn't necessarily have to be the same person for finances and for healthcare. And oftentimes it makes sense to have two different people because folks have very different skill sets and very different strong suits, as it were. Your eldest child might be a financial whiz, great with budgeting, and that might be a really good choice for your agent for finances. Whereas maybe your sister or your cousin or somebody else, or your youngest child, for example, really is in tune with what you intend in terms of healthcare decisions. So it's okay that they're different people. And one thing to think about as we kind of talk about all these fiduciary positions, agents for healthcare and finances, we'll talk about personal representatives and executors, we'll talk about trustees. Those are all kind of under the umbrella of fiduciary positions. When you're kind of knighted, so to speak, with or charged with acting on behalf of another, those types of positions are not an honor, they are a job. So it's very important to think clearly about who makes sense in those roles. And, so many times I get folks who say, well, I have 3 kids and, I should probably put all 3 of them on here. Well, not necessarily. You don't want to get too many cooks in the kitchen, so to speak. And it is, maybe your oldest child has 8 kids and 6 dogs and 3 cats and a lot going on. So maybe that's not necessarily a great choice. It's really important to kind of drill down and think about who would make the decisions and do the things that I would do if I were able to communicate them. The other, just briefly, type of document that we include as kind of this foundational piece of an estate plan is a disposition of remains statement. What happens to my human remains after I'm gone? Do I want to be buried? Do I want to be cremated? How do you want those things to be handled? And many of you in this room might be People's Memorial Association members, and oftentimes, particularly in our state, folks are cremated. We just have a higher rate for that than in other parts of the country. And so maybe you say, yep, cremate me. I've cited the RCW. That's what I would like done. Sometimes folks say, I like to have my ashes scattered, X, Y, and Z, things like that. And you can include those types of details as well, but really drilling down to, do you want to be buried or cremated or green burial? How do you want those things handled? And Washington allows us to make such a statement, so that way it can be followed by our executor following death. Go ahead. Yes.
And if you're a veteran, you can be buried in a veteran cemetery on the Air Force Base.
Ooh, good point. If you're a veteran, you can be buried in a veteran cemetery on the Air Force Base, you say?
I know I'm an Air Force vet.
Oh, okay. Excellent.
Yeah.
So any vets, talk to this gal because she has some additional information on that. But yes, so this is the point. You put that in your disposition of remains statement, make sure that your wishes are carried out. In terms of kind of the biggie, so to speak, I told you exactly what I think is most important, the first tool, because you're still living. But a lot of times folks have most questions about wills and revocable living trusts and kind of how those fit into the big plan, because they're leaving your things behind to your heirs or your friends or your organizations that are near and dear to your heart. So how do those work? Well, you won't have to raise your hand, but who in this room thinks that they have an estate plan? Well, in my mind, everybody's hand should be raised, because even if you haven't drafted a will or a trust, the good folks in Washington have prepared RCWs, the Revised Code of Washington, and they say, if you do nothing, here's what will happen to your things. So intestate succession. So even if you have an intestate estate plan, you still have an estate plan. So what happens then? How do you give away these things? Well, if you do nothing, then you die intestate, and Washington law will govern. So essentially, assets will go to your spouse, to your children, if there are none, up the chain to parents, if there are none, down to siblings, out to nieces and nephews. It can get quite a lot of arms going before you reach somebody. Interestingly, I had a litigation matter a couple of years ago. It was 2 spouses. The second spouse died. They both lived to be like 90 something. So they had very good long lives. They were both only children, and they didn't have any children. So what we were faced with, and they had like $1 million. It wasn't a small amount of money that we were talking about. But what was happening is they were only children, so no siblings. Their parents, of course, were gone. So you go down to the siblings of parents and their descendants. So their assets were going to be going out to these essentially second cousins twice removed that they didn't even know. They had no relationship with these folks, but maybe they cared about an organization or a family friend or something along those lines. So sometimes Washington and state statutes fit the bill, but sometimes they don't. So it's important to specifically direct where you want your things to go if you want to have a say in that. You have a question?
Yeah, I have a question. What was the difference from the will and the trust?
So I'm going to talk about that. What's the difference between a will and a trust? I'm going to get to that very thing. There's some significant distinctions and we'll talk all about them. So we have the question of, do I want to die intestate? Probably not so much. So the first kind of primary tool that we use in terms of getting rid of our things after we're gone is a will. And that's something that most folks in this room are probably familiar with. You've at least heard the word. And in Washington, wills are very common because we, unlike states like California, we have a probate system that is not clogged and not particularly expensive and not particularly onerous. So typically for most Washingtonians, regardless of the size of your estate, a will can typically be the best choice. But we'll talk about some circumstances where a revocable trust might make sense as a foundational tool, but by and large, wills are A-okay in Washington. So I mentioned that wills are subject to probate. So what is that dirty word? What does that mean? Because we do hear folks say, oh, you have to avoid probate. Or Susie Orman, she wants everybody to have a revocable trust in all 50 states. I'm not sure where she's licensed to practice, but lucky you, in Washington, you might not need one. So what's the probate? What is probate? It's the process, it's a court supervised process of basically gathering a deceased person's assets, paying their creditors, and distributing those assets according to their wishes. So you go to the courthouse, you pay your $250 filing fee, you file the will if there is one. If there isn't, you file under the laws of intestacy, and you're off to the races. Then there's a person who's appointed as either executor or personal representative. If you have a will, you appoint that person specifically. If not, it's any person over 18 who's not a felon that decided they want to administer your estate. The court will say, okay. So then you go through, and just like I said, you give notice to creditors. You make sure that, hey, anybody, if Tiffany Gorton owed you money, you got to speak now or forever hold your peace. And then you pay legitimate creditors as those claims come in. You gather all the assets. You find all the accounts, all the investment accounts, all the checking accounts. Where's the real estate? Where are the bonds? You know, all these different things that we have. You're charged with gathering all those things, going through, desks at home, going through the papers, going through the tangible personal property. All the things that I own at my death, my executor or my personal representative is charged with gathering those things and making an appropriate distribution of them. So again, the probate process, you alert the court that this person has died, you pay your filing fee, and then you get on to giving notice to creditors, paying claims, and making distributions. In addition to that, you are charged with filing the deceased person's final income tax return if one is due. So again, we're here on tax day. If something were to happen to me here in 2019, next year, when my 2019 individual income tax return is due, my personal representative or executor would be charged with filing that. If I had got to that place where I aspire to be, the taxable estate, then the personal representative is required to file the appropriate estate transfer tax return as well. So that's really kind of the business end of estate administration is through that probate process, and the court just is there to make sure that things are moving along accordingly. They don't interfere unnecessarily. Once things are indeed complete, you file a declaration of completion, you let the court know you're done, and 30 days later, that thing is closed. Go ahead.
So if I've already appointed certain people, like you're mentioning, take responsibility for certain things, when I die, they have to go to the court to finalize everything. Is that correct?
In most cases, yes. So if you had draft your will and you appoint your executor, I appoint Sally Sue as my executor, and Sally Sue takes my will and files it with the court when I die. If I have assets that are less than $100,000 and no real estate, then there's not going to be a probate required. If I don't fall into those two qualifications, like I do have real estate and it's owned in my name, then she's going to have to open a probate and she'll say, okay, time to sell Tiffany's house, time to distribute the proceeds to the beneficiaries. So does that make sense to you?
Yes, and does the court, if for anything I've already declared, I've already taken care of, does the court have to confirm, go through and, verify things that would cost my executor dollars?
So the court stays in its lane, so to speak. They don't want to spend a lot of time overseeing an estate. They're just there as like I say, they give you letters of testamentary. They give that to your executor, which allows your executor to go out and do the correct thing under the terms of the will, but they're not there checking in with your executor, so to speak. When the court gets involved after they've given out those letters testamentary, after the probate's essentially open, the only thing they do is sort of sit there unless there is a dispute. So if somebody gives $50,000 to Sally Sue and was supposed to give it to George, then George can complain to the court and then the court would get involved. But the court doesn't unnecessarily kind of keep tabs on things.
This is in county court.
In any, you can file the probate for a deceased person's estate in any county in the state. So I work primarily in King County, and sometimes I have folks that die in Kitsap County. The courthouse is 3 blocks from my office. We file the probate in King County.
Still, if you had already prepared your will, and then if a person died, the person inherited those will, they still have to show that to the court.
I'm sorry, say that again.
I mean, if you had assigned all the, distribute your asset to your, inheritance to the person in your will, that if a person died, like if I died, still my inheritance person have to show the paper to the court.
If one of the beneficiaries dies, you mean?
Yeah, in the will.
In the will. So typically folks will either elect to, I want only the people I list in my will are going to be receiving these gifts. If they predecease me, then they're out. Their gift it lapses, it goes away. Or they can say, okay, here are the list of primary beneficiaries, but if they die leaving children of their own, then I want the assets to be distributed that way. So you can choose how you designate beneficiaries in your will and whether or not you provide just for the specific folks that you list, or if you want to have, if they predecease you and you want to have their children essentially take in their place.
No, but I mean, after I die, how do they distribute those? Have to go to the court to do it, or have to find a lawyer to follow my instructions?
So you don't necessarily have to have a lawyer to follow your instructions. What happens is I die, my will is at my house in my filing cabinet, which is fireproof and is safe. I die, my next of kin, either my spouse or my family members are going through my things. They find my will. Then the person who I've listed as executor, Sally Sue, takes that will, goes to the courthouse, and files it with the court. The probate proceedings are begun. Then Sally Sue has the authority to make distributions of my stuff according to the terms of my will and pay my creditors and gather all of my assets and basically administer the
So
estate.
you have more than one person to inherit.
It's okay. You can have as many beneficiaries or folks inheriting things as you want. It's really the executor who is charged with taking the will and filing it and going to the court, correct?
You have to decide who's going to be the executor.
Yes.
I don't
And-
even have any family left. That's set up a trust.
Okay. So we'll talk a little bit about differences between the will and the trust and why that works in certain circumstances. Go ahead.
I'm not sure I heard you right. You can have 2 executors or only 1?
You can have as many as you want, but I recommend 1. You can have co-executors, but if it makes sense under your circumstances, like I say, sometimes people say, let me make all 3 of my kids executors, and that's okay. But as long as you have 1 appointed, and then I like to have at least 1 backup appointed. So in the event that Sally Sue dies before me or can't do it, then George can do it as the second person. And if you want co-executors, you can have them, but it is important that they make good sense for your circumstances. Yeah. Okay. So one really important piece to think about in terms of this kind of global probate issue that we're talking about is probate governs only probate assets. So it's easier for me to say what is not a probate asset than what is a probate asset. So if you have joint bank accounts with rights of survivorship, so your checking account, you and your husband are on your checking account together, or you and one of your kids, or you and your friend are joint tenants with rights of survivorship, that account is going to pass to that person that's designated as the joint tenant without going through the probate process. Similarly, if you have property that's subject to a community property agreement, you and your spouse say, everything is community. At my death, everything goes to my spouse. Your spouse doesn't have to go out and open a probate necessarily. Life insurance policies, they have beneficiary designations on them. So I die, my gajillion-dollar policy goes to Sally Sue. She's the beneficiary that's listed on the policy. Those dollars pass via contract and no probate's required. When probate's required is for assets that are owned just by you. So if any of those accounts had no beneficiary designation or no joint tenant on them, then they would become a probate asset. Real estate, for example, unless you title it specifically as having a survivor on that piece of real estate, then that's going to kick you into probate circumstances. So it really just depends on what your assets are and how they're titled in terms of what is going to be governed by the probate process. One important piece to think about is minor kids. I mentioned that at the beginning. It's important to ensure that, one, if you have minor kids, you want to make sure there's a guardian named in your will, just in case something happens to you, and make sure that you plan for their financial future if you're going to leave them a gift. Same goes for grandchildren. I have an example. Mom and dad were divorced. Mom was estranged. 17-year-old daughter lived with dad, and he died suddenly. So here is a 17-year-old who is essentially an orphan, and she's getting ready to graduate high school, and dad had no estate plan. So she's going to turn 18, and then she's going to inherit, in this case, it was a lot of $1 million just outright before she even goes off to college. So those were probably not the plans that the dad had in his mind for her, but because he had not done anything, hadn't set up a will with trust language in it or anything like that. She, 6 months later, turned 18. Let me point out, during the probate process, she was driving around in his Porsche, probably also not what dad intended. But when she turned 18, she got those assets outright because under the laws of intestacy, she was the heir, and Washington doesn't take care to do planning for 18-year-olds. They're adults, and so his assets went to her directly. Now, what he probably envisioned for her, had he stopped to think about it, or maybe he did and just ultimately didn't end up executing, is, and what I recommend a lot of my clients do if you have minor children, is include trust language under your will that says, yeah, I want my one and only child to inherit all my assets. She's 16 right now. So maybe we put it into a trust after you're gone. And it's not that you're funding a trust during lifetime. This is all stuff that doesn't happen until after you're dead, after the will kind of takes effect, so to speak. But you can include language that says, yes, give my assets to my minor children in trust and make distributions, trustee, for health, education, maintenance, support for those young people. And maybe you include language that allows them to take withdrawals at ages 25, 30, 35, somewhere down the road where perhaps, Tiffany Gorton wasn't in any danger of inheriting anything at 18. She still isn't. But 18-year-old Tiffany probably wouldn't have been as responsible with finances as 25-year-old or 35-year-old Tiffany. So, in terms of kind of setting up those young people for success, making sure that there's some protecting language under the terms of either your will, including trust language, or if you decide to use a revocable trust as your primary tool, including language that doesn't just distribute outright those assets the moment that person turns 18. Yes?
I would like to set up a will for my 3 children.
Mm-hmm.
but I don't want, like if they should pass away, I don't want their wives to get it because I don't get along with them.
Sure.
So could you do something to say that it only goes to him, or if they get a divorce or something like that, that she doesn't get my money?
Absolutely. This is a great question, and this is one of the important points. Well, I want my kids to inherit, but maybe not necessarily their spouses. So what do? What I always recommend for folks, particularly if they don't want someone to inherit, period, is say that. So call that person out. I'm specifically not providing for Betty, Sally, and Kim, or whoever that may be, because then there's no question that oh yeah, she meant to provide for me. She just, inadvertently left me out. And I've seen this in your daughter-in-laws or your son-in-laws aren't necessarily in line to inherit if your children predecease. But you can include language to allow your grandchildren, if you so choose. You can say, you know what, I have 3 kids. I would like my assets to be divided a third, a third, a third. However, if one of them predeceases me or more predecease me, leaving their own kids, I want his share to go down to my grandkids. So we still have 3 separate shares. One goes to my son. My 2 daughters are already gone, so those 2 shares go down to their respective children.
But can you write in your will that in the event of them getting divorced, that she's not going to hold the money?
Absolutely. You can provide for specific language regarding if your children get divorced, or just that you don't want the family in-laws, the children-in-laws, to inherit. And under the terms of kind of the way that goes in Washington, unless you specifically provide for those in-laws to inherit, they're not treated as your heirs.
Because I don't want to confront them now.
No.
They can find out when I'm dead.
Exactly. And that's why I say putting just a little line in your will that says, I specifically am not providing for Roger or whomever. You don't have to explain it. You're gone when they're looking at it. So I have a funny story about that. On the litigation side, I did see mom had disinherited brother, and in her will she wrote, I hated to do it, Raj, but you know why. And I thought, what did Roger do? So we were able to ask him in a deposition what mom meant by that. And apparently he had married someone that mom didn't approve of. So there you have it. So Roger didn't get anything. And that's mom's prerogative, because like I tell all my clients, you earned it. So go ahead and spend it. Do what you want with it. Yes.
Is there a law in Washington that some assets have to go to your children?
No. So she's asking, is there a requirement that some assets go to your children? There's no forced heirship here. There is, in some other countries, I've dealt with some issues in Germany just completely randomly. And so I've seen that, but no. In Washington, anything you want to do with those assets, you can leave them to the garbage man, you can leave them to charity, you can leave them to your kids, you can leave them to anyone you want. There's no requirement that you have to provide for your children under the terms of your will. So what about using a revocable trust? Because we talked about a will in the probate process. And the other term that you're probably familiar with is revocable living trust. What that is there are a lot of different types of trusts. This very specific kind, the revocable living trust, is essentially a box. You change title of your assets to your trust. So instead of my house being owned by Tiffany Gorton, individual, my house now is owned by Tiffany Gorton, trustee of the Tiffany Gorton Trust. So you change the titling on your assets. That's called funding the trust. And it doesn't change anything from your day-to-day living. You still pay your bills and pay your taxes and all those good things in the same way that you would otherwise. But what you've done is you've created this little box called the trust, and you're putting assets into it. You can still access them as you see fit. You can revoke the trust. You can tear it up and completely revoke it if you so choose during your life. But what that does is it helps you to avoid probate if properly funded. So I just said I put my house into my trust. I put my account titles are going to be in my trust now, etc. So I've done a good job of funding my trust. I've retitled all my assets, so I don't own them as an individual now. I own them as the trustee of my trust. So then I die. There's no probate required. So what happens is I'm serving as the trustee of my own trust during my lifetime. Then I have Sally Sue as my successor trustee. So if something happens during life where I become incapacitated, fall and hit my head, something happens, I can't manage my own trust assets, Sally Sue, who's the successor trustee, can come and write checks on the trust checking account, pay the bills, similar to what we talked about with the durable power of attorney for finances. Then I die. So I hit my head, and then Sally Sue helped me during life, and then I died. And what happens next? No probate, right? Because I've properly funded the trust during life. So then Sally Sue says, okay, I'm following this roadmap under the terms of Tiffany's revocable trust, and I'm going to distribute the assets to XYZ charity and these individuals. So the process and the roadmap sort of look the same in that you can say under the terms of your trust or under the terms of a will, here's how I want my assets distributed when I'm gone. And that doesn't change. The real difference between the will and the revocable trust is you don't do anything in terms of changing assets during your lifetime with your will. You don't fund your will, so to speak. But with a trust, you do change the title. Like I said, my house is no longer owned by Tiffany Gorton. Now it's Tiffany Gorton as trustee. And so you do make those changes during your lifetime, and it's more of an active document, so to speak. With a will, you make sure that it meets your needs and all of your ducks are in a row, all of your beneficiaries are current, all of your executor language is ready to go. You sign it, it's witnessed, and you just put it in your safe, and then you don't think about it anymore. With a trust, after you make sure that all your beneficiaries are listed, your successor trustee is listed, and you sign, then you have to make sure that you properly fund the trust. So you have to do a little bit of legwork with respect to those assets, like calling up the title company and finding out how is your house owned, and then transferring using a deed from Tiffany R. Gorton as an individual to Tiffany R. Gorton as trustee of my trust. So there's some additional legwork. It's more of a contract process there. But it makes sense in some circumstances. Oh, yes.
I'm confused. We have a trust, and one of the bank, we didn't fund the trust per se from a bank account, but we have death beneficiary to go to the trust. So
okay, that's okay too.
is that like funding? I mean,
So that will work, and you can see that with like in Washington, you can see this in certain deeds. We'll have what's called a transfer on death deed. So like my husband and I own our house together, but at the second spouse's death, this language is included in the deed. At second spouse's death, transfer it to the Nick and Tiffany Revocable Trust. So yes, what you're saying is you have an account and it's intended to actually fund the trust after you're gone. You don't have like your children or anyone else listed on it, but the pay on death beneficiary is this trust, and that's fine. Yes?
other than avoiding the probate, what would be the main advantage?
That's a great question. So other than avoiding probate, which we already talked about isn't particularly onerous in Washington, what are the reasons? So sometimes folks want to have privacy. So I told you in a probate, you file the will after somebody's gone, it's filed with the court. Trusts don't get filed. The only people who are entitled to see a trust are beneficiaries of it and the trustee. Those are the only folks that see it. So say you have a black sheep out there that you think might make some trouble when you're gone, come along and try and contest something. Well, there'll be more hoops for them to jump through when using a trust. So it's sort of a privacy concern. The second really important time that I'll recommend it for clients is if you have out-of-state real estate. So I don't, but say I own a house in Idaho and I'm a Washingtonian, but I don't want to have an ancillary probate in Idaho and a probate in Washington. So I use a revocable trust. Idaho house is in the name of the trust, Washington house in the name of the trust. Then there's no probate requirement here or in Idaho. So if you want to make sure that your vacation home doesn't cause you your heirs or your beneficiaries to have to do something else in another state. Yeah, go ahead.
So I think a while back you said that you would also put your investments under the revocable trust.
Mm-hmm.
We have a revocable trust. So if you haven't done that, what happens?
If you haven't done that and then the account doesn't have a beneficiary designated on it and it's over 100,000, then you will need to use the probate proceedings, or sometimes you can use an affidavit of lack of probate in order to transfer that after you're gone. But typically what's going to happen is you're going to have to open a probate, or your executor will, in order to transfer that account.
So do you need to talk to a lawyer to get that straightened out?
Not necessarily. You don't actually have to hire counsel for any of this. I recommend typically that you do, but in terms of making sure that your accounts, any accounts that you have, investment accounts, checking accounts, life insurance policies, you can contact those companies directly and let them know, hey, I have this trust and I want to change the title on the account. And they'll have language that they'll help you with. So, okay, I'm going to take one more and then kind of wrap up. Yes, ma'am. Yes.
I have a question about some big financial, organization, when you deposit money to like a bank or a stock market, those kind of fund, they had already asked you what your assignment to after you die, if you do.
Right.
They had already asked you last night. So is that equal to your will?
It's not equal to your will. You're asking, there are beneficiary designations associated with those accounts and life insurance policies and other types of financial assets. And so you put Sally Sue as the 100% beneficiary. Well, if that's your only asset and that's where you want it to go, that might be just fine for you, because that asset will follow that beneficiary designation. But when you have circumstances where you have some other things that need to be taken care of, and tangible personal property, things like that, and in 9 times out of 10, you should really have at least a simple will, regardless of whether your bank accounts are are current with your beneficiary designations. And I'm going to leave you with this. I see this a lot on the litigation side. It's very important to make sure that you have a comprehensive, your complete plan. So whether that for you is, I want to die intestate, I just want to use a simple will, or I have some accounts with beneficiaries attached to them, beneficiary designations, or that joint tenant with right of survivorship language. It's very, very important to make sure that what will happen to those assets is your current intent. So don't draft a will and say, I want everything to go to 1/3 each to my 3 children, but then have your only asset, your checking account or your investment account with one child as a joint tenant with right of survivorship. Because what will happen is you will die, that account is now owned by that one person that you've listed, and the will says divide everything 3 ways. Well, if the account was the only asset, the account's gonna follow that beneficiary designation or that joint tenant designation, not the will. And that's not what you intended probably. But I do see that a lot in terms of folks saying, I wanna add one child who's local to my checking account so they can help me by writing checks. I understand the sentiment, but what happens most often is that the bank will add that person as a joint tenant with right of survivorship, not just as a signor. Their default oftentimes is just to make that person basically a co-owner. And then you die and that asset goes to that co-owner, even though what you really intended was that that was gonna fund basically your whole estate and be divided among your 3 kids. Check your beneficiary designations. Make sure that your bank accounts reflect your actual intent. If you want somebody added just as a signer, make sure that that's how they're there, that they're not a co-owner or they're not a designated beneficiary. And if you have a financial power of attorney that you've executed, you won't have to add anyone to your bank account because that power of attorney gives them the authority to write checks for you on your account without being an owner on your account. So with that, I appreciate your attention and all the good questions. And again, if you have other questions, feel free to shoot me an email. I know we had a lot to cover in this brief period.
So thank you, Tiffany.
Thank you.